So California just made their last-ditch effort to protect their magazine and assault weapons ban. So let's talk about this. But real quick before we jump into this video, I want to thank one of the sponsors of this channel, which is Blackout Coffee. Blackout Coffee is a coffee company based here in the US, and they are huge Second Amendment supporters. They have dedicated roasts that donate money to GOA and FPC. So I highly recommend you check out Blackout Coffee. And if you go to their website and you use the code ARMSCHOLAR, you can get 10% off of your order. Also want to mention that right now we are actually approaching 500,000 subscribers. We are at like 480,000 subscribers, which is absolutely amazing. I would have never thought we would be anywhere near 500,000 subscribers. So thank you guys so much for all of your support. And I just wanted to mention that if you're not currently subscribed to the channel, or maybe you thought you were, double check because YouTube always unsubscribes people. But if you find value in this content and you want to support this channel and help me reach that goal of 500,000 subscribers, consider subscribing to the channel. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we will be discussing the Duncan v. Bonta, the Miller v. Bonta, and the Rody v. Bonta California cases. These cases are a challenge to the state of California's ban on so-called large capacity magazines, the state's ban on so-called assault weapons, and the state's restrictions on ammunition. These cases are currently waiting for Judge Benitez or Saint Benitez to issue his final decision. But California and the Attorney General just made their last-ditch effort to have Judge Benitez change his mind and instead rule in their favor and uphold these laws as constitutional. Now, I'm not going to go through all the procedural history of these three cases. If you want more information on these cases, you can watch some of my prior videos. But what you need to know for this specific video is that these cases have already made their way up to the Ninth Circuit prior and have already had a determination by Judge Benitez prior. Judge Benitez originally ruled that the magazine ban, the assault weapons ban, and the ammunition restrictions are indeed unconstitutional. Now, after the Supreme Court issued their decision in New York State Rifle and Pistol Association versus Bruin, these cases were then remanded back down to Judge Benitez for him to reconsider in light of Bruin. One of the primary reasons for the remand of these cases was because the Ninth Circuit's prior use of the two-step approach and also their use of interest balancing, which was expressly rejected by the Supreme Court in Bruin. So these California cases are essentially starting over and went back to Judge Benitez for him to issue a new ruling. Now, all of this came to a head at the beginning of last December on the 12th, when all three of these cases were in front of Judge Benitez. Also, the FOTUS case, which deals with billy clubs, came before Judge Benitez for a hearing. What ended up happening at that hearing was that Judge Benitez gave the state of California 30 days to present a spreadsheet of enacted laws and regulations which relate to the cases at hand. Then after that original 30 days, he gave the plaintiffs and the defendants 30 additional days to rebut all those examples and an additional 10 days for them to then file their replies. So essentially, he extended the case out, put it in queue for a little bit longer, which ended up being 70 additional days. Some of you may ask why Judge Benitez did that, and likely he did that to mitigate some of the arguments that the state of California is likely going to try to make on appeal. The state of California has already signaled multiple times in these cases that they're going to try to argue up to the Ninth Circuit on appeal that maybe there were some sort of procedural errors, or that they weren't given the appropriate time to produce the evidence which is required under Bruin. I think Judge Benitez did all of this to try to mitigate some of those arguments that will likely pop up on appeal, and so that's why he did give them some additional time. Also, keep in mind that recently you had reports that are circulating around about allegations of misconduct by Judge Benitez. Again, all that's in response to, I think, these three cases. And in response to this, the Ninth Circuit is reviewing that misconduct, reviewing that incident, and will decide what type of actions need to be taken. So there's a whole lot of kind of mess that's going on, and it directly deals with these three cases. Currently, in all these cases, all the briefs have been submitted, and we are simply waiting for Judge Benitez to issue his final decision and rule on, once again, whether or not he believes these laws in the state of California are indeed unconstitutional. But recently, California filed a notice of supplemental authority, citing to an 11th Circuit decision which upheld Florida's prohibition on the sale of firearms to 18 to 20-year-olds. This is California making one last-ditch effort to try and get Judge Benitez to rule in their favor. In this notice of supplemental authority, California is citing to a clearly flawed 11th Circuit decision, which is already in question by the 11th Circuit. There has already been a judge in the 11th Circuit who has stayed the issuing of the mandate of that decision and instead is polling the other judges in the 11th Circuit to decide whether or not that case needs to go en banc to review what the 3-judge panel in the 11th Circuit ruled, which the state of California is trying to use as additional authority. That simply means that one of the judges in the 11th Circuit found this decision so flawed that he took it upon himself to force a review by all the judges in the 11th Circuit. And that is the decision that California is trying to use in support of their laws. The notice that they filed to Judge Benitez reads, "Please take notice that on March 9th, 2023, the United States Court of Appeals for the 11th Circuit issued an opinion in National Rifle Association v. Bondi, upholding, under the Second Amendment, Florida's prohibition on the sale of firearms to 18 to 20-year-olds. The opinion is relevant to several arguments raised in the party's supplemental briefing concerning the proper application of the text and history standard announced in New York State Rifle and Pistol Association v. Bruin, and identification of the relevant time period to be examined in determining the nation's relevant traditions of firearms regulation." The state of California likes that 11th Circuit decision, obviously, because it came to a determination that Florida's 18 to 20-year-old restrictions was constitutional. But also, California likes how the 11th Circuit came to that conclusion. The 11th Circuit relied primarily on later history as a basis to come to that conclusion. They did this instead of looking at only the relevant history dating to 1791. In this 11th Circuit decision that California is using, the 11th Circuit stated, "But constitutional rights are enshrined with the scope they were understood to have when the people adopted them. And as our history shows, the states have never been without power to regulate 18 to 20-year-olds' access to firearms. Going back to the Reconstruction era, that is exactly what many states around the country did. Indeed, many states, when the 14th Amendment was ratified, banned 18 to 20-year-olds from buying and sometimes even possessing firearms. And they did so to address the public safety problem some 18 to 20-year-olds with firearms have long represented." So that is the decision and authority that California is relying on and now submitting to Judge Benitez as relevant for these 3 cases. Now, why is this relevant? Well, because the 11th Circuit is relying on Reconstruction era laws, which dated from 1863 to 1877. Now, that is a far cry from the 1791 historical support, which is mandated by Bruin. California, and the reason why they want this, also heavily represented and leaned on Reconstruction era history in their arguments in the Miller, Duncan, and Rhodey cases. And that's why they're advocating for this decision, and that's why they're presenting it to Judge Benitez as to how he should analyze these California cases. They're essentially saying the 11th Circuit found in a way that we like. They used Reconstruction era history as relevant. We presented Reconstruction evidence and history in our briefing. Therefore, you should rely on that also and not just stick to 1791, because the state of California really struggled in these cases to find relevant history dating back to 1791. So for everyone asking me what's going on with California in these cases, the magazine ban, the assault weapons ban, the ammo ban cases, that's where these currently stand. We are still waiting for a decision from Judge Benitez. California is still trying to submit additional authority to support their position, to try to persuade Judge Benitez. They're also attacking Judge Benitez any way that they can with the misconduct allegations. But ultimately, I don't think that's going to change any of this. I think Judge Benitez will still issue in a way that's pro-2-way and strike down these California laws. But if anything changes, if anything develops, I will let you all know. If you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.